Welcome back, Legal Eagles, to another explosive courtroom breakdown. Today, we're diving headfirst into a whirlwind of legal drama, questionable decisions, and shocking revelations that will leave you absolutely speechless. We've got Mr. Grayseye, initially charged with unlawful carrying of a weapon, now facing an open felony warrant for fraudulent use of identifying information, a charge he vehemently claims was supposed to be thrown out. Then, we'll shift gears to Miss Collins, a young woman grappling with intellectual disabilities and a judge determined to push her towards employment, despite her mom's heartfelt pleas. And just when you think you've seen it all, we encounter a repeat offender on bond for DWI, who manages to pick up another DWI, complete with open containers and spilled alcohol in her vehicle. But the drama doesn't stop there. We'll witness a judge's exasperation with a defendant's repeated drug violations, leading to a shocking array of conditions including an ankle monitor and random drug tests. Each case unravels with its own set of twists, turns, and emotional appeals, exposing the raw human element behind the cold facts of the law. Prepare yourselves, because these are not just legal proceedings. These are deeply personal struggles playing out in the unforgiving glare of the courtroom. Stick around as we break down every moment, every ruling, and every emotional plea. You won't want to miss a single second.
All right. Good morning, Mr. Grasse. Sir, you're charged with unlawful carrying of a weapon. The reason that we took you into custody, you have an open fraudulent use or possession of identifying information less than 5 items. Right now, it's an open warrant and there's no bond that's set, so I can't let you go. If I let you go now, not only would I get in trouble, but both of them would get in trouble as well. When you have an open felony warrant, we're not allowed to let you go.
Monday was the court case for that, and I came to court with my attorney. They told me that it was going to be thrown out for no probable cause, and I was free to go. And they would send it to the grand jury, and the grand jury would issue a warrant for my arrest. And at that time, I would possibly go through another case and get indicted.
He's right.
I understand that, but it actually has it down as a failure to appear on the 7th, and it was verified as a good warrant. Yes.
My attorney was with me as well.
So I don't even have a listed attorney here. Who is it?
CEO Swisher.
I don't know if I have. I don't know.
So I want to say it's out of the 178th. Oh, 248.
Yes, sir. On the 16th.
The 178, I can call him.
Yeah.
And I believe this other gentleman.
So I'll let you, when we take you back there, I'll let you, do you have her phone number? I'll let you make a phone call to her to see what can happen. But when there's a felony warrant, I can't let you go. I see that they found no probable cause, and I don't understand why the warrant is still active. I have no idea. Typically, when like a judge finds no probable cause, a judge still has to sign a motion to dismiss, and that would end the case. Here, I see the magistrate found no probable cause, but I don't see a dismissal, and that may be, I don't know. We'll let you reach out to Ms. Swisher, and then hopefully she can advise you more. So we're going to do probable cause in this case. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
October 30, 2024, officer observed a red Tesla Model S fail to stop for a stop sign at the intersection of the 5000 block of Holly Street and South Rice Avenue. Officer initiated a traffic stop and the vehicle quickly accelerated into the parking lot of Bel Air.
Talk about a curveball. Mr. Grayseye comes into court expecting his fraud case to be dismissed, only to find out there's an active felony warrant for his arrest. This highlights a critical and often frustrating aspect of the legal system. Even if a judge finds no probable cause, the case can still be pushed forward by the grand jury. It's a stark reminder that judicial decisions can sometimes be bypassed or reevaluated, leaving defendants in a state of legal limbo. The communication breakdown between the court and the defendant's attorney, Ms. Swisher, is a significant red flag here. How often do defendants fall through the cracks due to administrative delays or miscommunications? This scenario underscores the importance of diligent follow-up and robust legal representation to ensure that all parties are on the same page regarding a case's status.
High school where the vehicle came to a park. The defendant exited the vehicle and began moving quickly toward the school. Officer tried to block the defendant's entry into the school to further conduct the traffic stop. The defendant was immediately uncooperative and repeatedly claimed he did not know what a traffic stop was. Officer asked for an ID multiple times, but the defendant kept saying he forgot his ID. The defendant stated he did not have a Texas driver's license, but had one from North Carolina. The defendant was placed into custody for traffic violations. The defendant's wallet was removed from his pocket and checked for an ID. Defendant's North Carolina ID was located in the wallet along with a social security card bearing his name and a second social security card with the same name but with a different SSN. During an inventory of the vehicle, officer located in the center console a Glock 9mm semi-automatic pistol, which was reported stolen out of North Carolina. On the floorboard behind the driver's seat, officer located approximately 0.5 grams of marijuana. Later in the investigation, it was determined the defendant also does have a Texas driver's license.
Is it possible? Licenses from multiple states?
Not supposed to. You're supposed to surrender your out-of-state license when you get a Texas one.
You can't have multiple licenses.
It's after 90 days of residing in the current state, you have to dump the other license.
Correct. I thought it was 2 weeks.
No, it's 90 days.
90 days.
Did they change it?
Yeah, they must have, because when I moved here, the same thing happened. I saw a letter that told me I have 90 days to surrender. Yeah.
This is Mr. Grasset.
Is he on the docket, Judge?
Yeah.
Yes.
GRAI. What's weird is that it looks like the 248 found no probable cause, but there's still an open felony warrant. That
Yeah, it looks like it was direct indicted 2 days ago, Judge.
Talk about a curveball. Mr. Grayseye comes into court expecting his fraud case to be dismissed, only to find out there's an active felony warrant for his arrest. This highlights a critical and often frustrating aspect of the legal system. Even if a judge finds no probable cause, the case can still be pushed forward by the grand jury. It's a stark reminder that judicial decisions can sometimes be bypassed or reevaluated, leaving defendants in a state of legal limbo. The communication breakdown between the court and the defendant's attorney, Ms. Swisser, is a significant red flag here. How often do defendants fall through the cracks due to administrative delays or miscommunications? This scenario underscores the importance of diligent follow-up and robust legal representation to ensure that all parties are on the same page regarding a case's status.
I don't think I've ever seen it go that quick. Wow.
It looks like the prosecutor may have already had a grand jury day. They just said, I'll just add the case. Yeah.
That's
Pay
why.
attention to the judge, not the
Indicted.
computer.
Yes, sir.
That's why.
Could you explain that to me?
Did you need me to?
Yeah, please. I'll have your lawyer explain it to you, okay? Because I got a bunch of people waiting. But it's a good warrant. That's all I'm going to tell you. It's a good warrant. I am going to find probable cause in our case here, okay? I want you to understand, do you have a Texas driver license? Okay, you're not allowed to drive. I'm making that a condition of your bond. Unless you have a Texas driver license and liability insurance, you're not allowed to drive. I'm going to have you sign an affidavit promising me you're not going to drive. I assume that you're going to get out, right? You have made bond in our case. As soon as Ms. Swisher gets up there, I'm sure they'll get you a bond and you'll be able to bond out in felony case, but don't just start driving. If you want to drive, go get a license, get liability insurance, come back to me, show me, and then I'll take the restriction off. The only other condition I'm going to put on you at this time is don't have any weapons, okay? As long as you can abide by these conditions, you'll be fine with me. I'm going to appoint you a lawyer now. If Ms. Swisher at a later time decides to sign on to the case, great, but we'll give you a lawyer for now, and then you can also explain what's going on to that lawyer now.
Am I still able to explain to Ms. Fisher?
Yes, yeah, I mean, we'll take him back now and I'll give you time to make a phone call, absolutely. Do you have any questions?
May I ask, why are you finding probable cause?
The gun is stolen.
Is it?
That's what alleged.
And Matt, ask one more question.
Sure.
You all said that it was moved to grand jury 2 days ago. Is that the time that the warrant was issued, or was the warrant issued following the court?
So what happens typically is as soon as a grand jury indicts a case, that it simultaneously issues a warrant at that time as well. So what they do is they'll typically have around at least 9 to 12 independent people listen to the facts of the case and decide whether there's enough probable cause. Just because one judge finds no probable cause, they can still take it to a grand jury and have it indicted. That's what they've done. And they do it to me too. Like, I'll find no probable cause in a case. If they disagree with it, they take it to a grand jury and still have it indicted. So just because I found no probable cause, that's not the end. Okay. All right. Good luck, Mr. Brasse. And
The judge's explanation about the warrant being active despite no probable cause is a crucial legal point. What this means is that while a preliminary hearing judge might not find enough evidence to proceed, the prosecution can still present the case directly to a grand jury. If the grand jury decides there is enough evidence, they issue an indictment and an arrest warrant. This is a powerful tool for prosecutors and can catch defendants completely off guard, just like Mr. Gracie. It's a bypass mechanism designed to allow more rigorous review, but it can certainly feel like a legal ambush to those involved. This scenario highlights the multifaceted nature of the justice system, where different judicial bodies can reach different conclusions, each with significant implications for the defendant.
happy Friday.
Yes, it is. It's a busy Friday. I'm approaching on London Collins. She's on the docket today on the bond docket. As part of her bond conditions, you ordered her to find full-time work. She is on Social Security disability because she can't work.
Why?
She's got intellectual and learning disabilities. I'm getting documentation from mom. Mom is here, so I don't know if you want.
Okay, yeah, bring mom,
Okay.
mom, come up.
And this is Miss Collins and mom.
Hi, Miss Collins. Thank you. Mom. So you're okay. Thank you so much for coming. Do you know what happened?
Yeah,
Do you want to hear it? What happened?
Well, I believe she was also on the
I was on FaceTime
when the
when
incident.
the incident happened.
Okay, so, I mean, if you want to go through it, we can.
No. I just wanted to know whether you knew about what happened or not, so you know.
Yeah.
Okay. I'm the firm believer that if you have too much time on your hands, you become self-destructive. In this life, your brain craves activity. You need something to do, whether it's, working, schooling, something, a hobby. And it scares me that she's sitting at home doing nothing all day. I don't know. You know her obviously better than I do. Is she able to work?
To be honest with you,
Even a part-time job?
she did have one, at Complex, being a host. She was only working there like on Saturday and Sunday.
That's great.
It was a situation that happened where she's very emotional, and a customer hollered at her, and she was crying. So she called me to calm her down, and her manager did not that. And so,
Hence it spiraled out of control.
right, so they sent her home, and I calmed her down and everything, and I told her it's okay. Don't take it personally. It's dealing with customers.
And Ms. Collins, she's right. The problem is that when what was it she was doing?
This is a fascinating turn of events. The judge is clearly puzzled, as are we, by how quickly Mr. Gracie's case went from a no probable cause finding to a direct indictment by a grand jury just 2 days prior. This is incredibly fast, suggesting the prosecutor was highly proactive and perhaps had a grand jury date already scheduled or quickly arranged. It's a strategic move by the prosecution to circumvent the initial judge's decision and push the case forward, signaling that they believe strongly in the merits of their case despite the earlier finding. This swift action effectively overruled the initial judicial assessment, proving that in the legal world, a no probable cause ruling isn't always the end of the line. It underscores the tenacious nature of prosecutorial efforts in certain cases.
She holds different parties, like children's parties. Funplex, I don't know if you're familiar with it. It's like a like it has like a arcade and things like that, rides for children.
You know, Ms. Collins, when you work in this type of industry, like either the restaurant industry or the type of work where you have to make people happy, it's really tough because, you know, as my marketing professor once told me, you can't be all things to all people. It's impossible to make everyone happy. You know, me here in this job that I have now, do you know how many people I make upset? I've got so many people breathing down my right neck at this very moment because they're unhappy with me, right? And, you know, but we still try to do the best job we can, right? So that industry is really tough because even no matter how hard you try to make someone happy, someone's still going to be unhappy. And the idea is that when you face that person, you got to break away. And even if it's for, you know, a minute, 5 minutes, 10 minutes, you just go away, go to the bathroom and you know, be by yourself. You know, next time if this were to ever happen, ask to go to the bathroom. No one's going to follow you in the bathroom. And that's the perfect time to call mom. And then perhaps at that time she can, you know, but the problem is she going to stay at home do nothing all the time?
No, I try to help her find things that she's interested in. Like all her life, I put her in, even in school, different programs, different activities, band,
Great.
karate, orchestra.
Well, then I'll leave it with you. You know, I don't know all the circumstances of everybody that comes down here. That's why when I have like a parent or a loved one come up, and I love to talk to them so that they can tell me, give me insight of how this person is, what the quirks are, what they're doing, and because obviously you know better than I do. So, I mean, is she living with you now? Okay, so I'll leave her in your care then. If you don't think that, I'll take it off so that she doesn't have to, we won't make it a condition of her bond.
I want her to do things. I'm trying to find her things that she enjoys so she can make a career out of it and at least do something with her time.
The judge is setting some pretty strict conditions for Mr. Gracie's bond, and for good reason given his history. Not being allowed to drive without a Texas license and liability insurance, and the explicit instruction to avoid weapons, directly addresses the details of his arrest. This is the court attempting to mitigate future risks and ensure public safety. The fact that the judge appoints a lawyer despite Mr. Gracie already having Miss Swisser is a standard procedure to ensure immediate representation, especially with the felony warrant looming. It's a safety net for the defendant, ensuring they have legal counsel from the outset, regardless of prior arrangements. This multi-layered approach to bond conditions and legal representation is designed to keep a tight rein on defendants facing serious charges.
Ms. Collins, you need to understand that while she is absolutely fantastic and fabulous, she's not going to be here forever. She's, you know, you're going to get older. Things in life don't get easier. They get so much more difficult. And what you do now, you're setting yourself up for the next 40 to 50 years of your life. And if you don't set yourself some kind of career, something to do, when she passes on, you're going to have nothing. She gets disability now? How much?
They go by my income cover. He just actually started it back up again, so it's like 100. But it goes by my.
If you don't have income, does she get more?
Correct.
Okay, so perhaps it's a lot. I don't know. But is it enough to survive? Is it going to be enough to survive for the rest of your life? That's what you got to think about. Now is the best time for you to get a career, learn a hobby, learn a trade, and go with it. And perhaps.
She likes to braid hair.
Great.
And we went to go do that, and then she was like, we did all the steps, and she was like, well, I don't think I'm going to do that now.
You know, actually, we have a career fair that's coming in about a month. I can give you a flyer, and we have all kinds of different jobs, businesses that are going to be there. I'm going to be there too. I'm happy to meet you there, and we'll see if they have something that's to her liking. And if not, she's not obligated, but
She loves animals. That's another passion of hers. She
That's great.
loves animals.
hey, look, you don't even have to please animals.
She loves them.
Well,
Like,
if you feed them,
Great.
you're happy.
We gotta, yeah, that's
Yeah.
right.
she
Feed 'em.
loves them. Like, her and animals, they just come to her. She loves animals.
What about that? Work at a vet's office. You thought about that?
She's scared of like blood and stuff like that. That's
You're gonna see it, that's right.
Yeah,
Well,
so she's like, I don't want to.
I'll leave it to you. We're having a job and career fair at the beginning of November. Stop by. You have nothing to lose, just time, you know? And we have a bunch of other judges that are gonna be there to help other find jobs and other kinds of things. And, okay, well, I'll leave it to you. All right, okay,
But for now, you're okay with not having.
Yeah.
Okay.
absolutely. Okay,
Thank you.
all right, good luck, Ms. Collins.
Can we be excused?
I'm here on a case that has a warrant, 252
Hold on,
5791.
hold on. 252,
5791.
Alvarez.
Yes, Your Honor. And so I did not realize he had a warrant. We did get a pretrial intervention today on his felony matter. I've talked to the state there and to the chief here, and we have offers. I will stay on for the misdemeanor since this is.
So you're appointed on the felony.
I'm just trying to see if we could get a PR bond reinstated.
You here?
He's here. He's in the audience and the
Come up.
officer, Judge. Is counsel going to sign on to the case?
Yeah, she said she is.
Mr. Graysey's question about the probable cause for the new charge is met with a swift and unequivocal answer. The gun is stolen. This is the definitive factor linking him to a serious offense, elevating the entire situation. The fact that he was in possession of a stolen firearm immediately provides the necessary probable cause for the charge of unlawful carrying of a weapon and links back to the felony charge, which now has an active warrant. It's a clear illustration of how one piece of evidence can dramatically shift the legal landscape of a case. The discovery of the stolen Glock 9mm is not just a minor infraction. It's a major complication that completely justifies the judge's actions and the continued legal pursuit.
Because I'm a glutton for punishment.
Well, it's a good deal.
Well, we have an offer that we can do, but he did want me to see if there was a possibility of his PR bond being reinstated. It looks like he missed court on September 5th.
Why?
He had COVID, Judge, and he had been emailing previously on his previous court date with Ramona St. Julian Saunier. That looks like she was
The
right.
problem is that it's not his first time taking off. You know, we always give someone a courtesy when they take off one time, then yeah, we you know, to be nice, so to speak. But when you do it multiple times, at that point, it's just not the same, you know?
Just so the court knows, it looks like it was August 30th was the first setting, and then he was still positive on September 5th and reached out to her again, but he didn't hear back from her. He didn't know what was going on. He didn't, admittedly, he probably should have followed up with it, but and just asked me if you would consider reinstating his PR bond. Right now, it looks like the bond is set at $2,501.
Yeah, he's lucky it's not at 5,000 too. That's what I normally do. What kind of conditions does he have upstairs?
He's gonna have to do supportive outpatient, no guns, no new cases, just a standard PTI.
And Judge, I got an email from Sharma from her court. She would have never given this defendant PTI. She had no idea there was another case attached to it. She said this is not it's not a PTI
Brett's is still
case.
doing it up there.
Yeah.
Yes.
She said she would have never given a PTI in this case.
She's so
She
great.
knew.
Well, and
So that's why, I mean, I'm going to oppose a PR bond. I'd like the defendant to consider the state's
Let's
offer.
do this, Michael.
Yes, Judge.
I'm going to load him up with conditions. I'm sending you now for a drug test. I want to know what, if anything, is in your system. You know, your PR bond depends on if you're clean or not. You know, if you're clean, great. If not, then I don't know. And then I'm going to tell you now, I'm going to put a whole host of conditions on him. I'm going to give you an ankle monitor now because we can't trust you to be here on your own. And I'm going to drug test you like crazy. The next time you test positive, I'm going to tell you now, I will hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility.
Yes, sir.
Is that what we need to do?
Yes, sir.
This is your fourth case already in a matter of 4 months. Your first case was, well, I'm sorry, the case was filed in 23. You've had 2 dismissals in May of this year, and now you've picked up another 2 cases. You know, how many PTIs is this dude gonna get? So I'm sending you for a drug test.
Yes, sir.
It's late in the day, so are you working tomorrow? You'd be here tomorrow?
Well, no, he'd be here Saturday.
Oh, crap.
Judge, you wanted to come in on Saturday.
Right, I'm a glutton for punishment. Let's do this. So I'll send him for a drug test right now. I'm also going to put an ankle monitor on him. Monday, are you going to be here?
I can be here, Judge, yes.
You can always Zoom. I have Zoom so that it makes it easier for you as well. That way you don't have to actually physically be here. You can always Zoom in as well. We have it so that it makes it easier. What are you doing nowadays with yourself?
I'm working with my pop, sir. I'm supposed to be at work right now.
This is a fantastic explanation from the judge about the grand jury process. It clarifies how a grand jury, consisting of 9 to 12 independent people, can review a case and issue an indictment even if a lower court judge found no probable cause. This mechanism is in place to provide an additional layer of review and to allow the prosecution to pursue charges they believe are valid, even if an initial judicial assessment was otherwise. It emphasizes that a no probable cause finding at one stage doesn't necessarily mean a case is over, especially when prosecutors are determined to move forward. This highlights the power of the grand jury system and how it can override preliminary judicial decisions, leading to continued legal battles for defendants.
Okay, I want you back on Monday.
Yes, sir.
Then we're going to figure out where we're going to go.
Yes, sir.
Putting an ankle monitor on you now.
Yes, sir.
Curfew. I don't want you out in the middle of the night.
No, sir.
So 10 p.m. to 6 a.m. is your curfew.
Okay.
So I could put him in jail, but I'm just going to load him up with a bunch of conditions, Michael, and we'll see. We'll give him the keys to the jail cell. No dope. I want to know what if in your system now. If I find anything in your system that shouldn't be there, I'm going to have you come here even more to drug test you like crazy.
Yes, sir. Understand.
No weapons, no drugs, no alcohol, random urinalysis. And I'll waive the fee on everything, so he doesn't have to pay for anything. But I'm not going to do this again. Third one, then your bond is going to be really, really high. I'm going to tell you that now.
Yes, sir.
Understand?
Yes, sir.
Okay. All right.
Right, thank you, Judge.
Thank you.
So I have to reinstate it for that. Are you sure you want to do this?
Yes, sir.
You realize that, I mean, this isn't like Target where you buy something, you don't like it, you could return it, right? Once you plead guilty, I mean, you waive the right to appeal. So that means once you plead guilty, you can never come back and take it off and say, you know what, I changed my mind, I had buyer's remorse. No, there's no buyer's remorse here. This is a lifetime decision. Once you plead, that's it.
Yes, sir.
You sure?
Yes, sir.
You must also be aware that this carries now a mandatory minimum of 90 days in jail. Anything you pick up from now on, it's in here, misdemeanor court, it's a minimum of 90 days in jail.
Understand.
You understand?
Yes, sir.
Is weapons going to be forfeit, I would imagine?
Yes, Judge.
Okay. All right. You give up a lot of rights by entering into this agreement. We're doing what's essentially called time served. We're giving you credit for the time that you've served. You're walking out of here today. The bad part about it is that it'll end up on your record.
Here, the judge shifts from legal strictures to a more philosophical stance, highlighting her belief that having too much idle time can be detrimental. Her concern for Miss Collins's well-being is evident, as she encourages finding purpose and activity, whether through work, education, or hobbies. This isn't just about avoiding recidivism. It's about fostering personal growth and self-sufficiency. The judge's perspective is rooted in a desire to see defendants build stable lives, recognizing that engagement and purpose can be powerful deterrents against destructive behavior. It raises an important question. How much responsibility does the justice system have to facilitate personal development beyond just punishment? And is it fair to mandate employment for someone with intellectual disabilities?
Yes, sir.
You know, the other option you may have is to do a probation where if you complete it successfully, it doesn't end up as a conviction on your record. But the problem is you got to stay clean for quite a bit of time. And if that's not a possibility,
No problem, but yes, sir.
Did you want to do the care bond and then we can come back and do the recommendation?
you can do whatever you want to do, you know?
I mean, we can approach the judge. I don't know what you require to come to you with an agreed recommendation. The state's offering time served. They're not willing to offer deferred at this point. No, Judge.
Because you also are charged with the felony, they're not offering the probation. They've offered the time served, and I don't know if they're going to allow them to go without an agreed rec, meaning allow me to punish you and then put you on probation. I don't know.
I can certainly chat with them briefly if that's something that if they're willing to do, we can. He's already going to be supervised by probation for his PTI on the felony. So yeah, it's just a matter of whether the state's willing to waive their right to allow us to come to you.
What do you like to do? Do you just want to get this over with?
Yes. No.
No, I believe him when he says he just wants to get this over with. Yes, I feel like that's kind of what he wants, but do you want me to explore that option briefly? I'm still here.
Please.
Okay. Maybe.
Would you be willing to go out without an agreed rec on the,
No, Judge, not for this defendant. He's got a very serious juvenile ag assault SPI case and multiple PTIs. I'm not willing to do anything but attach it.
well, I don't see all these things. What happened with that?
He got a probation.
Is he still on probation for that?
No, Judge, but he's gotten scot-free on every criminal case that he's ever gotten, and he needs to answer for something today.
Do you see what's going on?
Yes, sir.
The more cases you pick up, the worse it gets. And the problem is that when you start picking up cases, when you're juvenile, when you turn an adult, for all intents and purposes, it's basically sealed, right?
Yes, sir.
Public is not going to 9 times out of 10 be able to see it, but now you're an adult.
This is a profoundly compassionate moment from the judge. After hearing Miss Collins's mother explain her daughter's difficulties and the challenges of finding suitable employment, the judge makes a critical decision. She removes the full-time work condition from Miss Collins's bond. This demonstrates a willingness to adapt conditions based on individual circumstances and a recognition of the limitations posed by intellectual disabilities. However, the judge's advice to Miss Collins about her future and the importance of finding a career or trade remains a powerful call to action. It's a tough but necessary conversation about long-term independence, highlighting the mother's role as a temporary, albeit vital, support system. What do you think about the judge's balance of compassion and tough love in this situation?
The more cases you pick up, the more unemployable you get. The older you get, the bigger, fatter, uglier, hairier, you lose hair. Just life doesn't get easier. Life gets more difficult the older you get. And the more convictions you get, the more unemployable you become, because employers don't want people with a ton of stuff on their record.
Yes, sir.
If you don't believe me, walk out there and ask everyone out there. It's not. All right. You're giving up a lot of rights by airing this agreement today. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this.
Sir, I understand.
You understand?
Sure.
Your only other option at this point is to set up a trial. So this is what you want to do?
Yes, sir.
Okay. How do you plead to the offense, sir?
Guilty.
I will find you guilty. I will send you to 3 days in jail. I'll give you credit for the 12 you've done. The weapon will be forfeited, so you're not going to get it back.
I understand.
Stuff the right way.
Yes, sir.
And Your Honor, I would
Thank you.
ask if the court custody
Yes,
motion currently.
of course.
Thank you.
Yes, absolutely. Okay. All right. Good luck, guys.
Thank you so much.
Thank you.
Thank you for coming in and helping.
Judge, on this one, yesterday I had zoomed in and got the court's permission for us to have this setting on Monday because
Oh, that's right. I remember.
I'm at the CLE and I'm about to run back in.
Oh, that's right. We had rolled this over to, we had rolled this to Monday because he couldn't be here. Cedillo couldn't be here. That's why.
And-
On Mr.
and-
Mann. That's right. No, I remember that. No. I guess were you supposed to email Victoria?
I did, Judge, yesterday.
She didn't get one.
I have been having it in my emails, Judge. I apologize. I showed up this morning to try and reconfirm it, but
Well, look, let's finish this real quick because, and we'll get you out of here. All I have is,
okay.
Mr. Mann has bond violations. Am I right?
Yes, Judge, but given the nature of the bond violation, I very much wanted to be there to speak to him and speak to the court.
He
It is
tested
his
positive for methamphetamine, John.
yes, Judge, that's why I would like to be there to address it.
Yeah, well, I guess I'm not letting him go. He tested positive for meth. His case is 1,300 days old. Am I right?
Yes, Judge, I believe so.
No, I'm sorry. You know, as much as I love you, John, I mean, he's testing positive for meth. You know, it's 1,341 days old. We give you multiple chances, and now you're testing positive for meth. And
This is a profoundly compassionate moment from the judge. After hearing Miss Collins's mother explain her daughter's difficulties and the challenges of finding suitable employment, the judge makes a critical decision. She removes the full-time work condition from Miss Collins's bond. This demonstrates a willingness to adapt conditions based on individual circumstances and a recognition of the limitations posed by intellectual disabilities. However, the judge's advice to Miss Collins about her future and the importance of finding a career or trade remains a powerful call to action. It's a tough but necessary conversation about long-term independence, highlighting the mother's role as a temporary, albeit vital, support system. What do you think about the judge's balance of compassion and tough love in this situation?
no,
Sir,
I'm sorry.
I can't even explain that to say I just came to court, my feels wrong, so I had to come. And I didn't want to play with you at all.
Look, I don't want you to say anything without your lawyer being present. You know, I can have him reach out to you in the back you know, we can always roll it to Monday too, and we can talk about it then. But I mean, when do we say when, Mr. Mann? You know?
So, yes, I hear you, sir. I understand everything that you're not trying to know, sir. I understand. I don't have an explanation for you.
John,
Can we keep him on for Monday, Judge?
absolutely, of course.
I understand the
Of course.
revocation, Your Honor, but if I can
Yes.
address it Monday.
Absolutely. We'll talk Monday then.
Thank you, Judge. I appreciate it.
Okay, bud. All right. Thank you for coming.
Yes, sir. Thank you.
All right. How's jail?
No.
Ok, eso es solo. ¿Cómo está la cárcel?
How's jail?
¿Cómo es la cárcel?
Fea.
Good. You now have picked up another DWI while you're on bond for DWI. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On October 13th, 2024, officers were dispatched in regard to a traffic hazard at West Belfort and Nobility Drive in Harris County, Texas. Upon arrival, officers met with the defendant, who was observed to be parked on northbound lane with her truck on and in park and asleep at the wheel. When the defendant finally woke up after multiple attempts, the officers observed glassy eyes, constricted pupils, an odor of an alcoholic beverage, and swaying, as well as multiple open.
This is a definitive moment where the judge lays down the law. She's not just reinstating bond. She's attaching a heavy list of conditions to ensure compliance. Ankle monitor, random drug tests, and a stern warning about the consequences of testing positive. Contempt of court, 180 days, and rehab are all designed to force accountability. The judge's decision to waive fees for these conditions also demonstrates a nuanced approach. She wants the defendant to succeed, but without financial barriers hindering compliance. It's a stark ultimatum, highlighting the court's dwindling patience, but also its persistent effort to guide the defendant toward sobriety and lawful behavior. Is this tough love? Or is it simply a necessary measure to protect public safety and compel compliance?
And closed alcoholic containers in the vehicle and spilled alcohol in the front
Alcohol
portion.
in the car while she's driving?
Yes, Your Honor. She was not the only occupant. The defendant admitted to consuming alcohol prior to operating the vehicle. Standard field sobriety test were conducted. HGN 2 out of 6, walk and turn 4 out of 8 in the one leg stand.
But not too fast, man. Thanks.
2 out of 4.
Dos de cuatro piezas en el paro de una
DIC was read.
Se leyó.
and the defendant consented to breath test. The results were 0.162 and 0.156.
Thank you.
Is that her? Ma'am, I'm going to find that there's probable cause to go forward with the case. What is that?
¿Qué es eso?
I don't think she reads English, Your Honor.
Okay.
If you want me to ask her if she knows if that's her signature?
Te firmó diciendo que no vas a manejar. Sí.
Es mi juramento.
It's my swearing. My affidavit.
I want to express my deepest disappointment.
Molestia más profunda.
And we ordered you not to drive, and you promised us you would not drive. And now
The judge's passionate speech about the cumulative impact of criminal cases on an individual's future is incredibly powerful and resonates far beyond the courtroom. He highlights how juvenile records are sealed, but adult convictions are permanent, making individuals unemployable. This isn't just about punishment. It's about the long-term economic and social consequences that defendants often don't fully grasp until it's too late. His advice that life gets harder, not easier, and that a clean record is crucial for stability, is a stark warning. It's a real-world perspective on how legal troubles can spiral into a lifetime of missed opportunities, emphasizing the need for defendants to take their current choices seriously. This moment serves as a powerful reminder about the lifelong implications of legal decisions.
you picked up another DWI.
Otro caso de manejo ebrio.
Which I've already spoken with the state. We're gonna see what we need to work out.
I don't know if I'm going to take anything today, Marcos.
She has been in custody for 2 days, Your Honor. I understand.
Entiendo.
It screams to me that there are issues, and the last thing I want is to have her go back out there and kill someone. I mean, we have 2 DWIs in rapid succession, 0.19, and a bunch of alcohol in the car.
I will say, Your Honor,
Allegedly.
and I've already spoken with the state about the first one. The first one is not a strong case for the state. She's the one who called 911 because she was assaulted outside of a club. The fire department got there before the officers. They saw her in the passenger seat with a bloody face. And her arm was injured as well. I've already spoke with the state.
I don't remember. All I know that there was enough PC to go forward. There's an affidavit. She promised us she's not going to drive.
I understand. There's also a question on the second one as to whether she was operating or not. There are 3 people in the vehicle. And again, all of this we're going to try to flush out with the evidence.
Sure.
That's where I was going to try to get her a bond.
I am going to set a bond, but I'm going to tell you now, because she drove in violation of the affidavit, I'm going to make it a high bond.
This case is another stark reminder of the challenges of repeat offenses. This defendant, already on bond for 1 DWI, manages to pick up another one. The details of the arrest: parked in a lane of traffic, asleep at the wheel, glassy eyes, alcohol odor, and open containers, paint a clear picture of dangerous behavior. The breath test results of 0.162 and 0.156 are significantly over the legal limit, leaving little room for doubt about her impairment. What's particularly alarming is the immediate progression from 1 DWI to another while still under court supervision. This pattern of behavior is exactly what judges and the public fear, as it directly endangers innocent lives. This situation highlights the inherent risks of granting bond to individuals who demonstrate a consistent disregard for court orders and public safety.
I understand.
You know, I'm setting both of your bonds at $15,000.
She does have an ISOL, Judge, so that's why, in light of that fact.
She does have an ISOL?
We just found out this morning, Your Honor.
Now, have an immigration
tiene
detainer.
de detención de inmigración.
Do you realize what this means?
¿Usted se da cuenta de lo que esto significa?
Who do you have here that depends on you?
Que depende de usted.
Do you have any?
Dos hijos.
My two sons.
How old are they?
¿Qué edad tienen ellos?
La niña 2 años va a cumplir el 20 de octubre y mi niño va a cumplir 6 años el 23 de diciembre.
October, my daughter will be 2 years old, and my boy in December will be 6 years old, I believe. 6 años, dude?
I was going to suggest in the event that you wanted to work something out, that I was wanting to do a TRAS to see how best to go forward. But now with an immigration detainer, that's just, there's no, let me ask you this. Do you think that you'll be able to get her an immigration bond? Do you want to try?
She already has an immigration attorney. There may be a chance.
Pueda que haya una oportunidad.
Perhaps.
She's only been in the country 3 years.
Solo está en el país por 3 años.
I don't know.
But if she were to keep both cases open, pay the bond here, go with immigration, the two open DWIs, I don't anticipate them giving her a bond. She'd be a danger to the community.
You guys want to try or no?
This takes a tragic turn. The defendant's revelation of an ICE detainer, coupled with her having 2 young children who depend on her, adds a deeply emotional layer to her legal predicament. An immigration detainer means that even if she makes bond for her criminal charges, ICE can still hold her for deportation proceedings. The judges struggle to find a path forward, acknowledging the weak first DWI case, but also the danger she poses, is palpable. The decision to resolve both cases and dismiss her to immigration is a harsh reality. It signifies that sometimes the criminal justice system's immediate priority shifts to immigration enforcement, regardless of the personal cost. This is a heartbreaking intersection of criminal law and immigration policy, leaving the defendant with an incredibly difficult future.
We can always try, but she would rather, she's not gonna be able to pay those 2 bonds and an immigration bond. And a lot of the fact that the first DWI is pretty weak. We're gonna resolve both cases, dismiss one, plea in one, and then have her sent to immigration, and then her immigration attorney is gonna try to get her bond with
Out of a person, then try to get a bond?
one, she's over there, yes, because if she goes over there with 2 DWI, she's not gonna get a bond.
Porque si vaya con 2 casos de manejo, no le van a dar fianza. Yo entiendo, eso es porque.
One mistake can literally cost you your entire life. And I don't know if you understand or get the gravity of it. I hope one day you do. One simple mistake. Over. Like I said, I'm going to find that there's probable cause. I'm ordering you, if you get out on one ankle, to put a GPS monitor and not to be out in the middle of the night. You will be given a 9 p.m. or 7 p.m. to 7 a.m. curfew. On your other ankle, you will get a scram monitor, so I know that you're not consuming alcohol. Again, I'm ordering you not to drive. But like we've said, there's an immigration detainer, so the likelihood of you getting out is probably pretty slim. Regardless, I'm going to set both bonds, or I'll set the new bond at 15,000.
And what, Your Honor?
15,000.
Su caso nuevo.
15,000 even?
Excuse me.
Yeah, 15,001. And I'm going to do the other one as well, 15,001 as well. You want to set off a week, 2 weeks? What do you want to do? I don't know if I'm prepared to do something today.
Can I run another court, handle some other stuff? Then
Of course.
come back, then I'll talk.
Take your time. I mean, I'm never going to say no. I guess we'll talk.
Okay. Thank you, Judge.
For sure.
Judge, we have one more.
Today, we witnessed the intricate and often unforgiving machinery of justice at work. From Mr. Graysey's unexpected felony warrant and the judge's meticulous explanation of the grand jury process, to Miss Collins's compassionate bond adjustment and the stark reality of life with intellectual disabilities, each case offered profound insights into the human element of legal battles. We saw the judge's unwavering commitment to rehabilitation through strict conditions for repeat drug offenders and the heartbreaking intersection of criminal charges and immigration detainers. These cases underscore the complexities, the personal stakes, and the profound long-term consequences that unfold daily in our courtrooms. The judge's rulings were firm yet often empathetic, balancing the need for public safety with individual circumstances. If you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.